Hi there, Wilsonville area Chamber of Commerce members, area business people. My name is Kevin O'Malley, your Wilsonville Chamber of Commerce CEO, and welcome. We all, as small business owners, just love the fact that government is always there to help us, and that's exactly what we're here to do. Is their latest effort for the last several years of being able to help us with the Corporate Transparency Act. If you've not aware of what it is, take a look in the comments. We have the original presentation from our guest, Aaron Bell with Buckley Law. And what that will tell you is why it happened. So we won't start there. But the most recent thing is that it is back reactivated again. So there was a court case. So welcome, Aaron Bell. Thanks for sharing time with us this morning.
Absolutely. Thank you for having me.
So here we are. What's up?
There has been a whole lot up. Just a little bit of background, very quick background,
please.
Because we're going to be throwing out some acronyms. The Financial Crimes Enforcement Network is the federal agency that was that is overseeing the implementation of the Corporate Transparency Act, and the Corporate Transparency Act is part of a larger effort by FinCEN to crack down on money laundering and other financial crimes. The whole basis of the Corporate Transparency Act, or the process that was implemented, involves reporting companies having to report who the beneficial owners are in those entities. And what we're talking about are entities that are registered or formed through a state agency. So what oftentimes happens is when you form a corporation or a limited liability company, for example, you have to register that with the Oregon or Washington Secretary of State. And that occurs in every single state. Those entities then are subject to the CTA, the Corporate Transparency Act. And those entities then, to the extent that they are, unless they are exempt, and that's a category that is defined in the Corporate Transparency Act, unless they are exempt, they are a reporting company. And the beneficial owners of every reporting company in the United States has to file a beneficial ownership interest report. It's often referred to as a BOIR. So what has happened since the CTA, the Corporate Transparency Act, became effective is that a number of different court actions have been filed in federal district courts across the United States. Probably the initial one in Alabama got the most notoriety because in that particular case, the federal district court judge said that Congress didn't have the constitutional authority to enact the CTA. Different courts subsequently have resolved the issues differently. And consequently, there is a state of total uproar and a mess, frankly, throughout the United States on the implementation and the enactment of the CTA. Most recently, a court out of Texas had issued a stay on the enforcement of the CTA, and that stay then was determined to affect everyone in the United States. The CTA, compliance with the CTA initially was going to take effect January 1. Mm-hmm. All entities that were formed prior to January 1, 2025 were required to file their beneficial ownership interest report immediately following January 1, 2025. And entities were required to file that BOIR within 30 days of the time that they were formed following January 1, 2025. So the stay went into effect. No one has known whether they should file, shouldn't file. A recent statistic that I saw was that over 50% of the entities in the United States, reporting entities in the United States that would otherwise have filed on January 1 are in a state of flux, waiting to see what the outcome of the court litigation will be, and consequently they haven't filed. Most recently, and the reason we're here, is that the courts have lifted the stay. Okay. And based upon that stay being lifted, FinCEN has issued guidelines and clarified new deadlines associated with filing the beneficial ownership interest report. For most reporting companies, the new deadline to file the initial BOIR is March 21, 2025. That's March 21, 2025. Reporting companies that were formed or registered on or after February 18, 2025 must file within 30 days from the date that they were created or registered. So if your entity was formed prior to January 1, you have until March 21, 2025 to register, to file your BOIR. If your entity was formed after January 1, you have until you have 30 days after 30 days after February 18 or 30 days after your entity is registered or filed to file your BOIR. I know it's confusing as all get out. We're trying to make it as simple as we can. We could go on ad nauseum as to how each of the courts have interpreted the CTA and why we are in this complete state of flux, but that's the best we can do at this point.
Okay, so that's amazing background. Thanks for the concise and insightful summary. So here we are as small business owners who are potentially looking at this and saying, okay, I fit the category as somebody that needs to be reporting, and I now have a new deadline that is March 21st. Without asking for legal advice here over Zoom, I imagine you have clients calling and saying, hey, I don't know if I want to do this or not do that. Can you kind of speak to the March 21st? And, these are all legitimate business owners that we're talking to. These are not the people that were targeted by the government in the first place because of all the money laundering and whatever. So they're trying to say, what do I do? Do I wait? Do I think something else is going to happen? Can you share some ideas at this point?
Our advice all along has been, a lot of it is dependent upon your threshold of risk.
Okay.
The penalties for the failure to comply with the CTA requirements, the filing of the BOIR, is a potential of fines up to $590 per day, or potential criminal penalties reaching $10,000. So the fines for the failure to comply with the CTA are severe.
Yeah.
In the background here, we also have the Corporate Transparency Act wasn't a fluky kind of legislation. It was built on a bipartisan effort to crack down on money laundering and other financial crimes. And it's been brewing and being developed over the course of the last 6 or 7 years.
Yeah.
So some form of CTA, whether it's this present form, but some form of CTA and some form of beneficial ownership interest reporting, we're certain it's going to exist.
Yeah.
So what we're advising folks is, if you want to hang on to the idea that the state of flux enables you to sort of hang out and wait, you'll have to monitor the cases. You'll have to monitor whether the legislation and the Supreme Court acts. FinCEN doesn't necessarily need to or have to extend the deadline any further. So again, it's dependent upon whether you just want to do it.
Yeah.
Get it over with, file your BOIR, or whether you want to hang out in that mess, try to figure out what your potential or long-term exposure is.
Okay. Very.
I know
very
that's
well.
a punt, Kevin.
It is the risk threshold, and that it takes a little bit of time. But again, in the comments, you can see the great information that was put up by the Buckley paralegal that we did on an interview. She did a fantastic job of saying how to fill out the form. So it's there. You have to choose, business owner. Do you want to sit back and watch? And as Aaron points out, which I hadn't considered until he mentioned it, you have to monitor it. So it's like, okay, does something happen while you're busy on a project where now it's back in effect again? You don't hear about it, and you've left yourself up for exposure. You counter that with, okay, I'm providing the government with information. Is that information fully confidential in most cases in this day and age, Aaron, or do you think that some of that information is I mean, we provide that, supposed to provide that to Secretary of State, right? In terms of, or not, is it?
Not all of the information. The beneficial ownership interest report requires the disclosure of anyone or any entity that has a control interest in a corporation or an LLC. Those folks aren't often disclosed in the registration documents that you file with the Secretary of State. So it does disclose some things that aren't now currently in the records.
Okay.
But there are some securities built into the CTA. For example, not everybody can get to the information. It would require a court order. So there are some protections and some securities for the information that you do file with the federal government.
And I won't put you on the spot because of all our current, here we are in February 27th, of the question about who has access to all kinds of federal information. It seems to be in the news. So that is a factor. So folks have follow-up questions, addresses and stuff are there. We can't thank you enough for taking time and sharing with us. Again, in our experience, we have many great attorneys and legal firms that are involved in our chamber, but there are not all of them that are actually stepping into to work on the CTA. Is that a fair statement?
That's a fair statement. Yep. That's a fair statement. And we're happy to help, happy to answer questions.
Good deal. Thanks again very much, Aaron. Buckley Law.
Thank you.
And
have a great day.
We'll tune in again.
All right.